Most divorces, by their very nature, are contested actions. That means that one party is seeking a divorce and the other party has been served with a complaint and summons for divorce. If you're served with a complaint and summons for divorce, you have 30 days to answer that. While there's no default for divorce in Georgia, the other party can seek a divorce if you have not attended a hearing and you've been noticed for a hearing. So it's your responsibility once you've been served to keep up with pleadings and notices with the court. That's no one's responsibility but yours as the defendant in a divorce action. It's important to answer every single item in the complaint and address those requests thoroughly. We sit down with you. We talk about your needs, the needs of your children, your property interests, how best to represent you in protecting those property interests, and that's how we move forward. Oftentimes, complaints for divorce are going to be served with discovery. That may take the form of interrogatories or requests for admissions or requests for production of documents. Interrogatories are questions that are submitted by one party or another. You have the right to submit them even if you've been served. If you're the party that's first served, if you're the defendant, you have 45 days to answer typically. And if you are the party in response to that and you're sending out interrogatories, the other side, the plaintiff, will have 30 days to answer. Same with requests for production of documents, only that is usually an opportunity for you to share relevant documents, things that might be important as requested by the court. In some counties, like Fulton County, they have standard interrogatories that you have to answer in addition to the interrogatories presented by one side or the other by either through their attorneys or individually. With regard for requests for admissions, they are particularly time sensitive. If you don't respond to them in time, whatever statement might be asserted by the other side may be deemed admitted to the court, and it's often very difficult to get those recalled. So it's very important that you respond thoroughly and on time. If there's going to be any sort of extension of time, it has to be by consent of both parties. So it's very important that in a contested divorce action, you take the discovery process seriously. Discovery typically lasts up to, and it doesn't have to take 6 months, but it lasts up to 6 months from the date that an answer is filed in the divorce. That doesn't mean that you have 6 months all the time. A lot of times, like I said, it's 30 days or 45 days, and time is very much of the essence. But if you want to request discovery, whether it's from the other party, whether it's from a third party or a non-party to the case, you have a very short period of time in which to do that or to get the ball rolling. So we take the process very seriously and we hit the ground running with discovery as quickly as possible. If the other side doesn't answer these, there is a process where you can compel the discovery responses, up to and including incarcerating the other person through a contempt action if they don't answer for the discovery. So we know how to bring that along and make sure that the questions you need answered are being answered, and we know how to answer for you in a way that's appropriate and thorough.